Welcome back to the deep dive. You know that feeling, right? When you sign something, words look clear, but somehow you and the other person are on completely different planets about what it means. Well, today we're tackling exactly that, a deep dive into communication breakdown in contracts. We're zeroing in on what happens when the written word just isn't enough, using the classic case Raffles v. Wichelhaus. It's a fantastic, almost riddle-like example of hidden danger in contracts. For you listening, we're going to dissect the specific legal tool a court uses to say, actually, this signed deal, it never really existed.
That's exactly it. And our mission here is pretty rigorous. We need to really get under the hood of latent ambiguity and how it hits that core contract requirement, mutual assent. Latent ambiguity isn't about breaking the contract. It's about proving it was never properly formed in the first place. We'll use a strict step-by-step analysis to show precisely how the court found there was no meeting of the minds in Raffles.
Okay, let's start with that foundation then, the absolute basics of a binding agreement. If I offer something, you accept, what's the fundamental legal hurdle for that to stick?
It all comes down to a meeting of the minds on the essential stuff, the key terms. Lawyers love the Latin for it. Consensus ad idem. If you and I are talking past each other about the main subject, what the deal is actually about, then that agreement, that assent, it's just destroyed. The court has to be sure both parties were aiming at the same target, so to speak.
And Raffles is where words spectacularly failed that test. Let's jump into the analysis. But first, a really interesting tidbit from the sources, the case report we have isn't like a modern judge's written opinion. It's actually a reporter's summary of the lawyers arguing back and forth in court. It's like a snapshot of live legal action from the 1860s. Okay, let's analyze Raffles v. Wichelhaus. First, what are the legally dispositive facts, the key details?
Yeah, the facts are surprisingly simple for such a famous case. Raffles was the seller, Wichelhaus the buyer. Contract for 125 bales of cotton from Surat. The crucial phrase was to arrive ex-peerless from Bombay. Simple enough, right?
Seems clear.
But the seller, Raffles, offered cotton from a ship named Peerless that sailed in December. The buyer, Wichelhaus, refused it. Why? Because they insisted they meant to buy cotton from another ship, also named Peerless, which had sailed back in October.
Wow, okay, so the contract looks like it was fulfilled. Cotton, Bombay, ship named Peerless. But Wichelhaus balked. Why did the specific month matter so much? It wasn't in the contract.
That gets to the heart of why the misunderstanding was material. Cotton prices fluctuate, market needs change.
Yeah.
It's very likely Wichelhaus needed that October cotton for a specific purpose, maybe a seasonal sale. Getting it 2 months late from the December ship, that could completely change the deal's value for them. So the timing wasn't trivial. It was commercially essential, even if unstated.
Got it. And what was the core legal issue the court had to decide?
The exact question was this. Is there a binding contract when both parties used the same term, peerless, but meant two entirely different ships, creating this hidden or latent ambiguity about the very subject of the deal?
What rule of law did the court end up applying? Can you state the full rule and break down its testable parts, its elements?
Right. The rule basically came from the winning argument made by the buyer's lawyer. It goes like this. If a term in a contract has a latent ambiguity, meaning it looks clear, but external facts show it can reasonably mean two different things and each party genuinely attached a different meaning to that term, then there's no mutual assent, no consensus ad idem, and therefore no contract was ever formed. And this rule has three critical elements. You need all three. 1. The contract has a specific term that turns out to be ambiguous about the subject matter, peerless. 2. The ambiguity is latent. It's hidden. You can't see it just by reading the contract. And 3. Each party attached a different, and importantly, a reasonable meaning to that ambiguous term.
Perfect. Thank you. Now for the court's elemental analysis. Let's break it down piece by piece. How did the court handle the first element, the existence of an ambiguous term?
Okay, element 1, the ambiguous term. The term was ex-peerless from Bombay on the page. Looks specific. But the external fact, boom, two ships with that name sailing from Bombay around the same time made it ambiguous in practice. Wichelhaus successfully argued they weren't just buying any cotton off a ship called Peerless, they were buying cotton off the specific Peerless they had in mind. Since two ships fit the description, the term failed to uniquely identify the subject matter. So, element 1, check. Ambiguous term identified.
Understood. Now, element 2. Ambiguity is latent external. This seems tricky because courts usually stick to the four corners of the document. The defense lawyer, Mellish, had to convince them to look outside the contract text, right? Why is that normally such a big deal?
That's a really key point about how courts work. Usually, the parole evidence rule is king. It basically says, if the contract looks clear and complete, we don't let in outside evidence conversations, earlier drafts, anything to change or contradict it. We trust the writing. But latent ambiguity is the classic exception. The problem here was entirely hidden latent. Reading Ex Peerless from Bombay, you have no clue there was an issue. It only popped up when you learned about the two ships from, say, shipping records like Lloyd's Registry. Mellish had to argue forcefully that the court had to admit this parole evidence, the fact of the two ships sailing in October and December, precisely to reveal the hidden ambiguity and show that the apparent agreement was basically hollow, lacking real mutual understanding. The court bought it. You can't ignore a fatal flaw just because it's not written on the page itself.
Right, you need the outside facts just to see the problem exists. Okay, that brings us to the crucial third element, that each party attached a different reasonable meaning. How did that play out?
This is where it all comes together. Raffles basically said, I meant the December ship, you should have known. Wichelhaus fired back, no, I meant the October ship, and that was perfectly reasonable.
Mm-hmm.
And the court looked at it and said, well, the contract didn't specify a month. Both ships perfectly fit the description. Peerless from Bombay. So was it reasonable for Wichelhaus to expect the October ship? Yes, given market timing. Was it reasonable for Raffles to intend the December ship? Also yes, as it fit the description. Now, if one meaning had been clearly absurd or commercially illogical, the court might have stepped in and said, okay, the objective reasonable meaning prevails. But here, both intentions were plausible, both reasonable. And because they were different, that essential meeting of the minds just wasn't there. Element 3, met.
So after ticking off all three elements, ambiguous term, latent problem, different reasonable meanings, what was the court's final conclusion?
The bottom line, judgment for the defendants, Wichelhaus. The court essentially agreed. Once you establish that latent ambiguity and show the parties were fundamentally mistaken about what they were agreeing to buy and sell, there's no contract. It was void from the get-go, never legally existed.
That step-by-step breakdown really highlights why Raffles is such a cornerstone. It shows a contract isn't just words on paper, it's shared understanding about what those words point to. But, that was the 1860s. Does modern contract law still focus so much on what each party secretly intended?
That's a great question. And yeah, there's been a shift. Raffles is often seen as emphasizing the subjective intent of the parties. What did they actually think? Today, especially in the U.S., courts lean more towards an objective theory of contract interpretation. They ask, what would a reasonable person, looking at the words in the context, think the contract meant? So if the ambiguity was minor, maybe about the exact shade of cotton, a modern court might try harder to find the most reasonable interpretation and enforce the deal. But, and this is key, the ambiguity in Raffles was material. It went to the core subject matter, which shipment of cotton, impacting delivery time and potentially value. Even under a more objective modern lens, such a fundamental misunderstanding about what of the contract likely means, most courts today would still say, no meeting of the minds, no contract. The principle holds.
So latent ambiguity, especially when material, is still a potent argument because it attacks the very foundation of the agreement. Okay, let's make this really stick. Let's ditch the 19th century cotton for a moment and use a maybe tastier hypothetical. Imagine a fancy restaurant buyer contracts with Captain Rick, a fisherman, for 100 pounds of Alaskan king crab from Captain Rick's boat, the Wanderer. The buyer is picturing crab from Rick's huge, state-of-the-art freezer vessel, the Wanderer I, known for top-tier deep-sea catches. But Captain Rick, maybe knowing the buyer likes quick, cheaper deals, intends to supply crab from his smaller, older day boat, also confusingly named the Wanderer II.
Okay, perfect setup. The Raffles analysis clicks right in. Element 1. Is the term the Wanderer ambiguous? Yes, because of the external fact of two boats with that name. Check. Element 2. Is the ambiguity latent? Absolutely. Reading the contract, you never know Rick had two Wanderers. You need that outside info. Check. Element 3. Different reasonable meanings. The buyer reasonably expects crab from the famous freezer vessel, Wanderer I, suitable for a high-end restaurant. The seller, perhaps based on past dealings or assumptions about price sensitivity, reasonably intends the catch from the day boat, Wanderer II. Both interpretations seem plausible in context. So check. Different reasonable meanings attached to the Wanderer. Conclusion. Just like Raffles, the material misunderstanding about the subject matter which boats catch means no consensus ad item, no contract. The buyer can walk away clean.
That makes it really clear. It turns this old case into a practical tool. So let's formalize that tool. For anyone listening, maybe studying for exams or just trying to spot this issue, what's the step-by-step checklist we can pull from Raffles?
Absolutely. This is the synthesis for tackling misunderstanding claims. Based on Raffles, here's a 6-step diagnostic. Step 1. Identify the term. Find the exact word or phrase in the contract causing the trouble. Peerless. The wanderer. Step 2. Determine ambiguity type. Is the problem obvious just reading it, patent, or do you need outside facts, latent? Raffles is about latent. Step 3. Use parole evidence, if latent. You must bring in those outside facts, the two ships, the two boats, to prove the latent ambiguity actually exists. This pierces the normal parole evidence rule. Step 4. Test intent. Did the parties actually have different things in mind when they used that term? Buyer meant October peerless, seller meant December peerless. Yes. Step 5. Test reasonableness. Was each party's interpretation plausible, sensible, reasonable given the circumstances when they made the deal? This is often the key battleground. In Raffles, both were deemed reasonable. Yes. Step 6. Conclusion. If you answered yes to steps 4 and 5 different meetings, both reasonable, then there was no meeting of the minds. Result. No contract formed. Void.
That's a fantastic framework, super clear. So the big takeaway really is, while we aim for objective contracts, a hidden, reasonable misunderstanding about what the words actually refer to can still unravel the whole thing if those words aren't specific enough. Okay, final thought for you to chew on. We've been focused on the contract being void, never existing, but flip the facts slightly. What if the Raffles contract had explicitly said, cotton arriving peerless sailing in October, and then Raffles, the seller, tried to deliver the December cotton? Is the issue still latent ambiguity and a void contract, or does that single specific date change the game entirely, making it a simple breach of contract case? Think about how just adding that one detail shifts the entire legal landscape.
That's the perfect closing question because it highlights the power of precise drafting. Once you specify October peerless, there's no ambiguity left to argue about. If the seller delivers December cotton, they haven't met the specific terms. It's no longer about a failure to agree, it's about a failure to perform what was agreed. That clarity transforms a legal fight from contract formation to contract breach, defines terms rigorously. That's the ultimate lesson.